Rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Lowe's.
Here.
Kettering.
Here.
Swenson.
Here.
Healy.
Here.
Summers.
Here. Do any of the commissioners have a reason to abstain for a financial or non-financial conflict of interest?
No.
I do not.
No.
I do not.
I do, Mr. Chairman.
Okay. Are you gonna abstain then and leave the
Yep,
room?
yeah, I'll
Okay.
leave.
All right, well, when we go into Board of Adjustment, we'll have you leave. All right. Is it a financial one or a
No,
non-financial?
just prior history with this permit.
Okay. All right, next item on the agenda, item number 4, approval of the agenda. Just so we know, there's a format for this hearing. I'll go over that real quickly. We're going to give 10 minutes for complainant's case. That's a combined time for all the complainants is 10 minutes. And then there's going to be a 20-minute for the permit holders to make their case, followed by a 20-minute complainant rebuttal, followed by a 10-minute permit holder rebuttal, and then 30 minutes for the Board of Adjustment to ask questions and have discussion. Everybody okay with those rules?
Yep, and I will be the timekeeper, and I can give alerts. So for the first 10 minutes, I can say 5 minutes left, 3 minutes left, whatever, just so folks understand when time is going to expire.
Additionally, we have a court reporter over here, and she's going to be transcribing everything, so I'd ask everybody to talk slow and clearly. And then also, everyone in the audience, it's very important, there are no sidebar conversations or talking or anything like that. So, all right, entertain a motion on the agenda.
Move approval of the agenda.
Second.
I have a motion and a second. Further discussion? All those in favor say aye.
Aye.
Opposed? Right, motion pass. Next item on the agenda, item number 5, public comment.
None listed.
No public comment. All right. Well, we will wait until 10 a.m. to go into Board of Adjustment. Okay, time being 10 o'clock, I'd just like to remind everybody, shut your cell phones off if you have them, and no talking from the audience, please. Entertain a motion to go into Board of Adjustment.
So moved.
I have a motion.
Second.
Okay, I have a motion and a second. Further discussion? All those in favor say aye.
Aye.
Opposed? We're now in Board of Adjustment.
I'll leave it this time, Mr.
Okay.
Chairman.
All right, now would be the time for the 10 minutes for the complainant's case. Are there any complainants that would like to come up? All right, this is a combined time, so if there's more than one person, it's 10 minutes for all of you guys. Come on up, state your name for the record.
Good morning. My name is Paige Herrig, live at Rural Mission Hill. And I'd like to start out with the fact that the conditional use permit number 3077 for the alleged violators Class D swine CAFO expired on April 1st, 2018, more than 1 year before legitimate construction was started. On page 16 of the findings of fact from the September 12th, 2017 Planning Commission meeting, it is stated, quote, "The DENR permit or requirement is started and will be properly completed before a building permit is issued," end quote. However, building permit number 3434 was issued on December 19th, 2018, and the DENR permit was not received until April 30th, 2019. The building permit, which was issued illegally, expired on June 22nd, 2019, also before legitimate construction began. Although spring weather and road conditions made construction of this type difficult or impossible, they are not legitimate reasons to excuse the alleged violations. Even if weather and road conditions had allowed for construction to begin earlier, the alleged violator's conditional use permit would still have been expired, and the alleged violator's building permit still would have been illegal. Even though the alleged violator was aware of the fact that he did not have a legally issued building permit and was aware of the fact that his conditional use permit had expired, he began construction anyway. This entire issue is the result of the alleged violator's ill-conceived decisions and actions. If the alleged violator had requested a new conditional use permit or an extension of the existing conditional use permit because of pending litigation, along with a request for a legal building permit, we would not be here today. Thank you.
Thank you. Does anyone else like to speak on this? Is there another complainant that'd like to speak? Going once, going twice. All right, seeing and hearing none, I'll go ahead and close the complainant's time. Move on to the permit holder's case. We'll give you 20 minutes. Welcome. Could you state your name for the record, sir?
Yes, I will. I'm Dave Domina. I'm here with Bo Barrett, and we're here on behalf of the JHGAS Farms. John Gunderson is also here with his wife and his family on behalf of JHGAS. I don't think it will take me more than 10 minutes. That's my goal. We have some materials to hand out to you. I've had the court reporter mark them as exhibits so that we can hand them to you.
Thank you.
Hopefully be pretty efficient at this. Thank you. I'll give you the issues. And I'd like to have Mr. Gunderson step forward for just a moment so he can affirm some things about what's in these materials for you, and then I'll explain with your permission. You're John Gunderson, correct?
Yes.
And Mr. Gunderson, you're a member of JHGAS Farms LLC?
Yes.
You're the manager?
Yes.
And have you looked at this packet of materials that I'm holding in my hand that has exhibits 1 through actually 16 in tabs and then some photographs marked as exhibit 17?
Yes.
Are you familiar with exhibit 1?
Yes.
Have you been informed by the County Planning and Zoning Commission that exhibit 1 is a letter that it prepared using your company's name that gets sent?
Yes.
And then are you familiar with the exhibits 2 through 16?
Yes.
Are those documents that were delivered to their addressees or locations, and they're genuine copies of originals?
Yes.
And were they all delivered as of on or about the date that they bear, either posted or delivered on those dates?
Yes.
And then at the end of the book, not at a tab number, but after a green piece of paper, there are some photographs. Are you familiar with the photographs?
Very much, yes.
And do those photographs depict the land of GHGAS that's the subject of the permit?
Yes.
And do they depict conditions as of the dates that the photographs or dates stand?
Yes.
So I think with that record, I can walk you through this and try to make our explanation of the circumstances as simply as we can. I organized these from newest to oldest by number, so to go in chronological sequence from the beginning, you actually start at the back of the book. And we might do that if you just follow me by tab number. I'll refer to the tab numbers and they coincide with the exhibit numbers, except for the photographs, which I'll save till the end. So exhibit or tab 16 is the original application for the conditional use permit, and you'll see that it bears 2017 dates down in the lower right-hand corner, and you're aware of action by your commission on it in the past. Tab number 15 is the building permit, which was issued after the conditional use permit was approved, and we're going to get to approval in just a minute, and long after it was applied for. The building permit was applied for in August of 2017. It was executed by the zoning administrator on December 19 of 2018, and it contains an express condition, which is that the findings of fact must be complied with, and the Department of Natural Resources of the state of South Dakota's approval and compliance for proceeding to construction and completion must be received. So it was issued with a condition. The conditional use permit, not the building permit, the conditional use permit was the subject of litigation in circuit court. Mr. Healy has disqualified himself because of that litigation, and we appreciate his decision. Exhibit 14 are the November 15, 2018 findings of fact of the circuit court judge, followed by some proceedings that included the attorney representing the commission, and followed by the notice of judgment. The notice of judgment is the last element in Exhibit 14, and you'll see that the circuit court executed a judgment approving the conditional use permit on December 12 of 2018. There was an argument made a moment ago that there should have been an application to extend the conditional use permit, but the CUP was in litigation throughout that time. So the circuit court had exclusive subject matter jurisdiction over that permit, and it did not become an effective or valid permit until the court ruled on the litigation, and when it did, the permit became valid, became usable, and it became possible to apply for the building permit, which was then issued on a condition a week later. The building permit itself with that condition appear in tab 13, just so they're a standalone item. And then at exhibit 12, or tab 12 in your book, you have the April 30, 2019 approval of the South Dakota DENR issued to JHGAS Farms. This is the item that authorized JHGAS to begin for the first time to use its building permit on site. Until this approval, the condition in the permit had not been authorized. So there is, we think, a legitimate legal question about whether the time from which the building permit's 180-day use period runs commences on December 19, when it was issued with a condition, or does it commence on April 30 of 2019 when the condition was satisfied? I want to just isolate and say for you clearly, we recognize there could be legal arguments about that date. We think the better position is that the permit became effective when the condition that is expressed in it was satisfied by the state and not vice versa. But because of what we'll present to you in a moment, that's academic in this case because actual construction clearly commenced in a meaningful way within 180 days of December 19, and therefore easily 180 days of April 30. But it is the Exhibit 12 that satisfies the condition precedent to activation of the building permit. Anticipating, because this has been a controversial subject in Yankton County, that there could be a claim made that December 19 was the effective date, anticipating that, Mr. Gunderson and JHGAS requested an extension of the conditional use permit and their building privilege, and that's in tab 11. They also had me write a letter to the zoning administrator and the state's attorney. Both of those are dated May 31, 2019, and my letter to Rob Klimisch and the zoning administrator is at tab or exhibit 10 in these materials. We are aware that on tab 11, the zoning administrator wrote, made an X, action declined, and a reference to the commission taking action. We have not had a chance to look at your proceedings, and I cannot tell you, I don't know whether you acted on that date or not. So I don't want to infer one way or another that I do because I'm ignorant on that subject. I just didn't get a chance to look before today and apologize to you for that. We put in exhibit number 9, which is a July 24 DENR letter. And this is simply to let you know that DENR was monitoring construction at the site as it proceeded. And this is simply an update on DENR monitoring. On August 3 of 2019, JHGAS, with my assistance on a letter that's on my firm's letterhead, communicated with the Yankton County State's Attorney and delivered a copy of the letter also to the Planning and Zoning Office. And that letter at Exhibit 8 sets forth a comprehensive history of all of the events and circumstances that we think bear on these issues, and I want to just note a couple of them that are important here. The gentleman who spoke for the persons who have complained mentioned that the spring season was so extreme in Yankton County that, I think to quote him, and I believe this is what he said, it either prevented or delayed and complicated construction, and it certainly did that. As of March 16, you had been forced by the conditions to close your own roads in this area. And those roads stayed closed for an extended period of time. So JHGAS, even if it had wanted to try, which would not have been prudent because your decision to close the roads is a good one, could not have got its construction materials in or out. There was a presidential disaster proclamation, which we've documented here. We've included your no travel advisory that you issued for the sake of the public, and we've followed through with, in detail, what happened after that. Now, while the weather conditions were so bad that the building site was inaccessible and the site itself impossible to work upon, the applicant was trying to get as much of the construction done as possible. So if you'll take a look with me at page 26 of Exhibit 8, I want to point out two things that are dated May 16 on that page. First of all, you can see that on May 16, there was construction material stockpiled. That's that first photograph in the upper part of the page. The second photograph is probably a little too close to be self-explanatory, but this is an image of the wood portions of the walls of the two buildings that now exist at JHGAS. They're now finished. They were constructed before May of 2016, and they consisted of 31,000 linear feet of wood clipped together with 12,800 metal clips. They were constructed off-site so they could be transported to the site to be erected. And as you know, modern construction very commonly builds things like kids, at least when kids were the age I was when I was a kid, used tinker toys. But now we build the whole building, its components off-site, ship it to the site, construct it in one location, erect it on the site. That's what had happened here. JHGAS had a substantial part of this, each of these buildings constructed long before the end of May of 2016, had them paid for, had the rest of it ordered, had people waiting to get them moved to the site as quickly as possible to get this building up and running. I put in number 7 simply so there would be no question about the date of completion. This is the engineer's, tab 7 or exhibit 7, is the engineer's certification to the DENR that the construction of the 2 swine facilities authorized by the permit, both the CUP and the building permit, had been completed. And then at tab 6, you'll see the state of South Dakota issued certificate of completion number 534 to JHGAS. And at tab 5, you'll see the correspondence that accompanied that permit. That was dated October 15 of 2019. Why it took from September to October after the certification, I don't know. At tab 4, we included we called it an admission of service. It's essentially a receipt of your deputy zoning administrator in which she simply acknowledged that we had physically delivered to her the October 15 correspondence from DENR with the certificate of compliance permit. Tab 3, or Exhibit 3, is notice of the complaint for today. Tab 2 is the appeal required to set the stage for the hearing today. And I would like to say that even though we appealed that, it is JHGAS's, not myself, it is JHGAS's position that its CUP and its building permit are valid and were complied with. And then, of course, tab 1, as Mr. Gunderson said, is the notification, which was handled by the zoning administrator's office. Let me just direct your attention for a few seconds to the photographs in the back. We included some photographs with date stamps on them simply to let you see that even at its most rudimentary on-site level, there was construction in progress by the 15th of May. Exhibit 17's first page is a photograph that shows the pillar point for the north wall of one of the buildings installed at that point. The second page is a better photograph of those rafters that I described before. The third page is a June 3 photograph of pipe laid in the ground and worked and in process of building the driveway, which was completed well before the 22nd of June. And you see some more of that work on the following page. On June 6, construction was in progress. This is a small structure, but it was designed and intended to be a part of the structure that would be used for the management of mortalities during the course of the process. The reason this small structure was built first, frankly, was because it was too darn wet to build anything else. We then included a couple of pages that show construction of the principal facility in progress. And you'll see that these photographs are dated after June 22. So the big structures definitely did come after June 22. They came as quickly as they could possibly come after June 22. And the final page we included is a photograph of October 17, 2019. And this is actually a photograph of the very first residence in the first of the 2 buildings, swine entering into the facilities themselves.
Sir, you have about 3.5 minutes.
Thank you. Took longer than I hoped to take, and I appreciate the warning. I hope that's been helpful to you, and we'll be happy to hear your questions in the question session. Thank you very much.
How much time is left?
3.5 minutes.
Would anybody like to speak for the last 3.5 minutes on the permit holder's case? All right, seeing or hearing none, I'll close that portion and now open it up for 20 minutes for a complainant rebuttal. Is there anybody from the complainants who would like to use this 20-minute time for the rebuttal? This is for all complainants as well. So come on up, sir. State your name for the record. Welcome.
Good morning. My name is Phil Taw. I live in rural Gayville. At the heart of this permit is the ordinance and the rules that are set forth within there. It's not about a long list of excuses and how things happened, and I appreciate the review of the facts of the case by Mr. Domina. Both the permit holder and myself and others have spoken at this very podium about being true to the ordinance and following it. The permit holder knows the ordinance intimately, and we both, he and I, believe that the ignorance of the law does not excuse not adhering to it. Even I myself have paid my fines and fees for a misunderstanding that we had. So, there are other excuses, other things we need to talk about. The CUP was approved in October 2017, and in September of 17, the DNR process was started. Why did it take a year and eight months? Were there other issues outside of his control also? He didn't mention that, but why it took over a year and 8 months to get his CUP. And knowing that process, knowing that delay, why wasn't that approached in with the planning and zoning administrator for a supposed extension, or how do we proceed with this matter? That didn't seem to happen. Furthermore, just because previous extensions, as they call them, may have been approved in the past, it doesn't make it compliant with the ordinance. There's no such provision in our ordinance for an extension of a building permit, a CUP, or anything else. That's what the rehearing is for, or the reapplication for a building permit or a CUP is about, so that those circumstances which caused that delay can be brought forth and a new permit's issued. It's really quite simple. What's not so simple is that in 2018, at the end of that year, a lot of permits were approved and rushed through because a new commission was coming on board, and I think they were probably afraid that something wasn't going to get approved. Even the building permit for this, with its condition, recognized about the DNR process needed to be approved before continuing construction. Why did you do that in December? Why not just wait until you got that approval, get your permit, clear up those issues so there isn't a legal question about which date we're supposed to follow? That zoning administrator wasn't elected or re-elected. He was still in place after the commission. The zoning administrator operates and issues the building permits as necessary. Yeah, it was a bad spring, but again, no effort was ever made to come in and talk about why. Even after you got the letter with the X on it saying your building permit is, or extension is disapproved, or your building permit is expired, what meetings took place to try and resolve the solution? The ordinance states in see which section that is. Essentially, in our ordinance in section 23, it talks about what the penalties for violations, or how to enforce those violations, or what to do when you were notified. And one of those things you're supposed to do is cease construction. This building went up in about 3 months, give or take. So it doesn't take necessarily a long time, but you do need good weather. I get that. And you need somebody probably building frames off-site. I understand that. But I'm sure Ethan Lumber probably builds a lot of those forms and has them ready to go for any number of buildings at any one time, even if you order them ahead of time. I don't have to get a building permit to hire a realtor to go look at a house or look at property, okay? We have to follow our ordinance, and if our ordinance is unclear, then let's clear it up. And we've been asking for that for a long, long time, even with the previous administration. And yet for 6 to 8 years, none of that would ever happen on their watch. And that's what we're trying to clear up now. This could have been cleared up by a gentleman coming into the zoning office and asking, what do we do now? How do we handle the situation? But he and others just simply thumbed their nose and said, we're gonna build anyway, and we'll let the chips fall where they may. I know they're not gonna make us tear that building down, the hog confinement. And I'm not asking you to tear it down. I'm asking you to enforce your ordinance, at least impose a fine of some sort, and set some precedents that here's how we need to handle business. Here's what our ordinance means to the people of this county, and here's how we're gonna enforce it. That's what we're asking for today, okay? Mr. Gunderson never talked in one of his, not excuses, but another reason. He had failing health or had some health issues, and I wish him well. I hope he's feeling better. But I'm sure that played in part of all this as well. So it seems to me that the excuses they use are the convenient ones to make their argument. I understand the facts and the timing of all this, but it doesn't change the ordinance and the wording therein. If we need to add some grace into our ordinance, we can, but that's what that rehearing is about. And I'm sure that the planning commission would have approved a new CUP. I'm sure this board probably would have approved a new CUP. You approved one in the spring of 2019 already, after you took office. And you added one minor condition about a monitoring well. Maybe that would have happened in this case, I don't know. Maybe trees, maybe a grass buffer strip so the manure can stay in the field. I don't know. But it's close to a ravine that goes down in the James River Valley. Would have seemed reasonable as a request, but I don't know where that would have gone. But I think it would have been approved. And I think his site is far enough away from a lot of folks in a lot of towns that it's probably not a bad place to have one of these if you're gonna have one. But just to demand it because you think you can do whatever you want in this county doesn't make sense to me. Okay? Thank you for your time.
Thank you.
Can you spell your last name for me, sir, please?
Would any other complainants like to speak for this time for the rebuttal?
We have 13 minutes.
Right, seeing or hearing none, go ahead and close that portion of the complainant's rebuttal and move on to 10 minutes for the permit holder rebuttal.
I will not use 10 minutes. I'm going to try to respond to the gentleman's key points, if I may, and perhaps give you just a little bit of additional information as I do that. First of all, of course, in terms of honoring and respecting the ordinance, what happened here is that after the conditional use permit was issued by this commission, the applicant and the commission were sued because there was a challenge made by citizens in a perfectly appropriate way to take an issue to court to see whether the conditional use permit had been correctly issued. That was a lawsuit that was not the choice of JHGAS or of the commission. It was the choice of the people who brought the case, and they exercised their right to go to court. We don't begrudge them that. We prevailed in that case. The county's position prevailed in that case. The ordinance was upheld. The conditional use permit which you issued was approved by the circuit court. The next step required by the ordinance was to issue the building permit. That occurred 1 week after the court ruled. Because the state of South Dakota has a voice in when this kind of structure is built, the conditional use, or the building permit, had a condition expressed in it. And that condition was also honored. So the issue here today is whether or not construction commenced within 180 days of whatever is the trigger date. The only reason there's an issue about the trigger date is because of this question. Does the subsequent approval of the state to commence construction activate the permit, or was the permit activated on December 19th? That's an issue that I don't think has been answered by the South Dakota courts, and the answer isn't found in your ordinance, as nearly as I can tell. So it's an open question. We present it to you in good faith today. We acknowledge a position that's different from ours as a good faith position. And if that has to go to court to be decided, we hope it doesn't, but if it has to, we respect the right that that must occur. Now, in terms of the good faith of this particular applicant, I want to make it clear, I am here on behalf of JHGAS, not some applicant that might be here next week, next month, JHGAS. These folks did contact your zoning office. They did it in writing on May 31. They did it on August 3, and as you read through the August 3 letter, you'll see that they acknowledge that they had communication with the zoning office on July 30. There was a meeting held with your zoning administrator at the time, Mr. McGinnis, and Mr. Plemish at Mr. McGinnis's office. I attended with JHGAS. We had a very professional, very appropriate communication at that time. And the upshot of it was that I agreed that I would write and send what became the August 3 letter. All of those were good faith negotiations. There was never an attempt to keep any of that in any way outside of the public view. In fact, quite to the contrary. And that's true of the state's attorney's office and the planning and zoning office as well. So we feel like JHGAS feels like it really did try here. Its principals contacted the neighbors before 2017 to inquire about this project. It's tried to be a good neighbor in this process, and it wants to continue to be. It's pleased to report that its facility is operating and that the neighbors are not complaining about it to their knowledge in terms of how it operates, but if they have complaints, certainly JHGAS wants to hear them. You may have issues that are different on the facts in some other cases down the road, but in this one it's very clear. The construction started here within 180 days of December 19. So you don't have to decide the question about what the activation date is because it's academic in this case. So we ask you to deny and decline to act on the complaint and allow JHGAS to continue to comply with your ordinances. Thank you.
5 minutes.
Anybody else care to speak on the permit holder's rebuttal? There's 5 minutes left. Right. Seeing and hearing none, I'll close that portion. And on to 30 minutes for Board of Adjustment discussion. And if we have anyone on the board has a question for the individuals, we can do that now. Does anyone on the board have questions? Okay. We got 30 minutes, so you want to,
Mr. Domina.
did you start the time?
No.
For
Yeah,
30
I did.
minutes? Okay.
Time started.
Go ahead, Don.
On the permit application, it said this permit will expire if work or construction authorized is not commenced.
Don, where are you at, so I can follow along?
On the application,
Do you got a page number?
page 9 of 51.
9 of 51. Thank you. Okay, I'm there.
I've heard you talk a lot about construction. I haven't heard any discussion about work. In my previous life, I saw many successful farmers that very seldom got on a tractor and did physical work, but they worked continuously behind a desk. Is there a distinction between construction and work? In other words, if they were working on various things during the process of this time frame, would that impact this?
Yeah, Mr. Kettering, in any construction project in particular, as I know you know from many years of experience, there's a term, pretty common term, that's called soft costs and hard costs. The soft costs often involve enormous amounts of planning and organization and staging and logistics, and pre-construction meetings, and even intra-construction meetings. which are different from swinging a hammer or even transporting objects onto a site and directing them. So there was all kinds of work like that that was required. The reason I emphasized the actual construction here is because it's also probably not entirely clear in your ordinance that a building permit is required to do some of that soft work. But it is required to do any of the hard work. And so I think the distinction is a fair distinction, and I think our position is strong enough on the physical work that I'm very comfortable submitting it that way, but I do appreciate your question.
Thank you.
Yes, sir.
Yeah, I have a kind of a general question. I'm just going to explain a few things before I ask the question. These 2,400 head hog barns, it takes about so long to feed them out after the hogs are brought in from wherever. My understanding is, I think Mr. ex-commissioner explained that it's about 2.5 or 2 1/3 cycles per year for 2,400 head, so that would be about, say, 6,500 head of hogs per CAFO per year. That's my understanding. The buildings are built by a different company from out of county. The materials, or some of them are local. Then they're shipped off to slaughter or wherever. But my question is, and it can be to all the CAFO owners, these hogs that are brought in, are they on your income tax? Are they on your Schedule F? Do you actually claim these hogs when you file your income tax, when you buy them, when you sell them, when they die? Are they on your Schedule F? And if not, then you don't really own the hogs. And our job as commissioners are to protect the people and the property of Yankton County. Well, of course, hogs are not people. And if those hogs don't belong to you, they're not your property. And that's my general question that I have. Are they on Schedule F? And I understand that you probably, if you get a check from these people or whatever, that's on your Schedule F. But are the actual amount of hogs on your Schedule F when you purchased, when you sold them, and the death count and the mortality, and do you claim that as a profit or a loss? So that's my simple question.
Mr. Swenson, in the case of JHGAS, and I only answer for them, they own the building and leased the building to someone else who owns the hogs. So the hogs are not on JHGAS's Schedule F. Mortality is not. The sale amount for the sale of the hogs is not, and the production costs are not. JHGAS would schedule the rental income and would have the deductions associated with owning the building, sir.
Okay, so he's kind of like my analogy would be, he's kind of like or Mr. Gunderson, and all of them are kind of like a extended motel keeper for people, you know.
In the cattle business, it's often called hoteling cattle.
Called what?
Hoteling cattle.
Hoteling cattle, yeah,
I
yeah,
think it's a slang term, but I've heard it many times in the
yeah.
cattle business.
Okay, well,
Sir,
well, thank you for clarifying that.
Sir, I have a question for you. On your photographs of the actual construction of this part here, now, most of these buildings, from what I understand, are really the same size. So the lumber that was constructed, is that, is it cookie cutter for every barn, or were these ones specifically built and created for this barn, or do they get shipped in and then it gets a tag that this one is going to this barn? Because they're all basically the same design, correct? Same length, width?
I can tell you, Mr. Klimisch, that the two barns in question in this case are identical.
Okay.
So the structural elements of the wood members that are shown in the photograph were identical for those two barns. I can also tell you that there was a specific order placed for a specific number for those two barns in these dimensions, and that those dimensions were on a unique set of engineering drawings. What I can't tell you is whether the same drawings changed for somebody else were used in 2, 3, or 4, or 5 other places.
Okay.
Insofar as JHGAS is concerned, absolutely a unique project.
Any other questions for Mr. Domina or anyone
Yes.
else? Go ahead.
In the 60 pages that were in our packet here, you mentioned a stay was issued by the judge. Do you have a copy of that stay?
I included in the materials only the judgment at the end.
Right.
There were earlier orders. I don't have them with me, but I'll be happy to get them to the state's attorney to get to you as quickly as I can after this meeting.
I would appreciate that.
I'll look for that and make sure that all orders that the circuit court did issue are available for you to see.
And also, I didn't see a site plan, excuse me, anywhere in our packet for what was supposed to be built.
Yeah, I didn't include a site plan because I was only interested for today in the construction. I would think the Planning and Zoning Office would have had the site plan.
Okay.
And of course, DENR has the as-built permits, or as-built plans now from the engineer.
And then on the last one was the meeting with State's Attorney Klimisch, Brian McGinnis, you, and the applicant, July 30th.
I believe so.
And then you sent the letter August 3rd.
I believe so. And my recollection of that could be corrected by Mr. Klimisch, but I put the dates August 26 and 30 in the letter, and I think it was August 30 that we met. But I'll stand corrected if Mr. Klimisch knows better.
Okay. And that
Not
letter
not
on...
August 30, July 30. July 30. My letter's August 3.
Right, and that letter essentially summarized everything you discussed during the meeting?
What tab was that on?
That's on
It's
8.
Tab 8.
8.
That would not be fair to say. The letter is more comprehensive than the conversation because frankly, I had more time to think about it.
Did you discuss during that meeting anything about applying for an extension?
We discussed the fact that there had been the 2 May submissions made, May 31 submissions made that you find at tabs 10 and 11.
Okay, because I did look up the meeting minutes on that,
June 4.
action to deny, Mr. McGinnis wrote, until the 6/4 commission meeting, which we did not take any action on 6/4, but on 6/18. We discussed at length the opportunity for anyone who felt their building permit expired to apply for an extension.
I don't.
And I was curious if that reflected in your conversation on June 30th.
I don't have a recollection of discussing either the June 18 meeting or an additional application. I made some notes during that meeting, which I didn't bring with me. You know, I do a lot of things in the course of my life, and I'm 69 years old, and I forget once in a while. But I don't think we had a conversation about
that.
And see Mr. Klimisch shaking his head in the negative. I hope that he's,
Okay,
thank you very much. Anything
thank you.
else?
Any other questions from anyone on the board?
If you're 69, you're born in 1950 like I was.
1950, Truman.
Any questions from anyone else? Do we want to take a few moments to go through anything? Any discussion? I'm going to take a few minutes and just read through some of this material.
Mr. Vedder, do you know of a site plan?
Don't recall off the top, it's, you know, the first week I was here, I went through the files and things, but I didn't go through a lot of them, but I seem to remember that there's a same plan.
Would you mind going up and looking for me? I think it's important.
That-
How much time does the commission?
There's-
It references on page 20 of section 8, a site plan.
Yeah, it's 2A, 2B, but I never saw it in the packet when I scanned through those.
waiting for that, maybe we could utilize a little bit of time. I would like to have a definition of exactly what a yes vote means or a no vote means. So there's no mistake on what we're voting on.
I would believe it's whatever the motion would be, so we could either move to uphold the zoning administrator's verdict or to overrule,
If we vote to
So, no
overrule, it takes all four of us to overrule.
right?
Am
So,
I correct? So,
for example, John makes the motion to overrule the zoning administrator's verdict. If you would vote yes, then you are trying to overturn. So I agree, Don, though, we need to be extremely clear when we make a motion. So as far as the, it seems to me a lot of discussion goes around what is the start of construction? And as has been stated in the, thank you, sir, in the ordinance, the zoning ordinance itself, it doesn't really outline a specific what is start of.
construction definition right here.
Okay, so I'm going to read this. It says, actual construction is hereby defined to include the placing of construction materials in permanent position and fastened in a permanent manner where excavation or demolition or removal of an existing building has been substantially commenced. Preparatory to building, such excavation or demolition or removal shall be deemed to be actual construction, provided that work will be carried out on diligently. So when you look at, and I know this maybe is maybe questionable, but this is from our floodplain ordinance, and it's a much more detailed start of construction. Includes substantial improvement and means the date the building permit was issued, provided the actual start of construction, repair, reconstruction, rehabilitation, addition, placement, or other improvement was within 180 days of the permit date. The actual start means either the first placement of permanent construction of a structure on a site, such as the pouring of slab or footings, the installation of piles, the construction of columns, or any work beyond the stage of excavation. Permanent construction does not include land prep, such as clearing, grading, and filling, nor does it include the installation of streets and or walkways, nor does it include excavation for a basement, footings, piers, or foundations, or the erection of temporary forms, nor does it include the installation on the property of accessory buildings such as garages or sheds not occupied as dwelling units or not part of the main structure. So that's just, I know there's a lot of question on what is the actual start of construction, and simply going out with a shovel and turning a shovel full of dirt is not construction.
But to that point, that's why I come back to on the application, the
Where are you at, Don?
page 9 of 51
Okay.
on our, it's our standard building permit application. And I come back to saying, the notice says this permit will expire if work or construction authorized is not commenced within 180 days, or construction is not substantially completed within 2 years of issuance. And it seems pretty clear to me that if there's work going on, whether it's construction work or work, there was a start to that process.
Can you show me where you're at on that document?
It's down here.
Right here. Okay, got it.
Where are you at, Don?
Page 9 of
Do you have that
51.
site? Do you have that
951?
site plan?
I don't have that.
That's because you don't have your application. You don't have the documents that were submitted to study before the hearing.
Thank you.
These are different, I see.
No, they're all
So-
pretty much the same.
I guess my point is, on our own document that's been signed by our employee, I guess, Pat, at the time, we talk about it expires when work or construction is not commenced within 180 days. That's a very important thing to me, because there's a lot of things that can be involved in work. It can be a process of working with the bank to get money approved. It can be a process of working with the zoning to get zoning things done. There's a number of things that go on that could extend this for a serious amount of time. And I guess that's my point. It's not just whether a building was up and out of the ground.
This small shed that was built, do we know where that is on the site plan?
Probably pretty close to the road, isn't it?
Well, I'm looking and seeing if I can find where this shed would be at on the site plan.
It's not on there.
How much, where are we at for time?
You have about 11 minutes.
Mr. Chairman, may I have permission to give those original exhibits to the court reporter to keep?
Yes, go ahead.
May we ask you questions?
So, yeah, please.
How much time do we have left? So where are we?
About 7.
7 minutes. I'll still need you to state your name for the record, even though we know who you are, Rob.
Rob Clemish, Yankton County State's Attorney.
Welcome.
I think from questions around your July 30th meeting, what can you tell us about that?
What page are you on?
It's the tab 8, is the summary letter from Mr. Domina.
Sure, the meeting would have been, there would have been an original, there would have been some complaints that were issued claiming violation of the ordinance. And so there would have been a meeting with Mr. Domina, Mr. and Mrs. Gunderson, myself, and Pat Garrity. Not Pat Garrity, I'm sorry, Brian
Right.
McGinnis at the time. And it was to discuss the complaint and for them to set forth the facts. Mr. Domina did supplement information after the fact, at the time. I know the delay, and what I'm referencing is to extend the time frame. It was brought up as in, it was my position and also Mr. McGinnis' position that this bomb cyclone was and I know we addressed it in prior meetings, I'm using the word act of God, position, where my position would be, and I think the law's pretty clear on it, that it's gonna extend time on these building permits and stuff, and that was addressed during the meeting, but it wasn't addressed that he needed to come back in and make a request or anything. I know there was a May 7th letter, I think, and then also there was that 21st letter, I believe, too, so. Yeah, I think there was so those letters would have occurred at that time, but it would have been addressed during the meeting, and that's how it was addressed, and then the point of the meeting was to get together and then establish if what the zoning administrator was going to do regarding whether there was merit to the complaints or there wasn't merit, and that was the original thing. That was kind of my position, and that was part of my thought is there needs to be an investigation, and I was sitting in there for the administrator the zoning administrator, just to sit in there and support him regarding what was going on, but it was the zoning administrator running the show.
And after that, was there an investigation?
The investigation would have been the submission of the information that Mr. Domina would have provided at the time. I do think, I could be wrong, I know Gunderson's had brought in pictures and stuff. There was a bunch of pictures, so I think those would have been submitted at that time. And some more information would have been submitted at that time. But my position would be that was the investigation that would have occurred. I just don't think it was ever completed. I think Mr. McGinnis was overwhelmed in timing and that he didn't get it completed at the time, Sherry, so.
Okay.
That would have been the issue.
So at any time during that meeting, was Mr. Gunderson advised or not advised to come in and get an extension?
He wouldn't have been advised at that time, Sherry, to get an extension, because I don't think it was brought up in front of the commission at that time. But I do feel during the meeting, their position was that, I think Paige Herrick used the date of the 21st, I believe, of June. So I believe their position at the time was they were still in compliance. And I know Mr. Domina references the DNR approval, extending time. Also, we had, again, the bomb cyclone, but I do believe, I do know that the Gunderson's position was, let's take out the bomb cyclone, let's take out the DNR to start the time. We believe that we commenced work as described in our ordinance. So I believe that was their position at the time.
So they did not feel compelled to come in and ask
didn't.
for an extension
Yeah,
because
and
they
sure,
felt they were in the right?
And my position and Brian's position at the time was the bomb cyclone would have added time to that. The roads were closed. I mean, it was something that was unforeseeable. We wouldn't have even anticipated that ever happening. It was never addressed. So it would have been brought up stating that, but I think it was more of a sidebar thing because their position was, we're in compliance and we're just letting you know and what you need from us. And then they did provide information after the fact and did do it in a quick manner.
Because we had the full discussion at the commission level on June 18th that essentially outlined the process to come in and officially get an extension, because we can't just give them willy-nilly, because that was determined by Supreme Court that you can't just automatically give extensions without the hearings as such.
And Sherry, I'm going to say it a little different. You don't have the ability to give extensions. We don't have the ability to give an extension, but I do believe under this circumstance, yeah, I'm going to use the
Right.
word, it's,
Yes.
I'm not even saying you would even have to do anything. I think it happens. I think a court would probably rule that it occurred because of the circumstances of closing down the road. I don't know if there's an act that you had to have done to get to that point. Does that make sense?
It does.
That would be I would believe that's what would happen. That would be my position. And that would have been my position during the meeting, and then that's been my position sitting in here and talking to the commission. That time frame would extend a building permit under this time.
Does state law guide for how long the extension is?
I would believe the time frame would be the time the roads are closed to the time the roads would be open. I think that would be a fair assessment of a situation of adding time to a building permit automatically due to the circumstances.
Okay.
But I do know their position at the time was they believed they were in compliance without the extension. That was their position. And then the
Right.
position as well, if you don't agree with us on that, we have a bomb cyclone, and in addition, the condition happened with the DNR in April, so 6 months started then, because that's a condition of the building permit, which then would make them in compliance easily, probably would be a good response to it.
Okay, thank you.
So we still have roads and bridge closed, so how long, I guess in your opinion, would that extension go, as long as roads are closed in Yankton County that?
Roads that would be servicing that area
Okay.
would be that, under those conditions, and then they would be unserviceable by another manner. Yeah, so like if you're not able to service and you're not able to add construction at the time, or do any construction, and I know you guys brought that up, but what we're dealing with is the building permit shall expire if the work described in any building permit has not begun. And I know that's what we're arguing over, construction, actual construction, but the actual 1725 says work described is what it says. And I know that's why we're looking at our site plans and trying to figure out if that was, work was started, so.
How are we doing on time?
Just expired.
Thank you. All right, that concludes the time for the Board of Adjustment discussion. Now, need a motion. Do you have any advice for us on a motion? Is the only motion that would really matter as a denial, right? Because to uphold, it would take 4 votes to uphold or 4 votes to deny. Is that?
It's gonna be 4 votes to overturn.
Okay.
That's how you'd have to do it.
So anything less than that, then the vote, then the decision remains valid.
Correct.
So, okay. So the motion we probably should do, regardless of your position, would be a motion to overturn or deny, and if that motion does not get all 4 of our votes, then Mr. Vedder's decision is upheld. Is that how you'd recommend, how would you recommend us?
I would recommend
Do-
it that way, Dan. That's how I
Okay.
recommend it.
So,
His decision will be upheld unless you overturn it.
okay, so his decision will be upheld, so regardless of how you'd like to vote, the motion should likely state to deny, and then we can vote, and anything less than 4 votes, everyone present here, will uphold Mr. Vedder's decision. So, are there any questions on that?
Should we make statement as to why we're voting the way we vote?
I think you can do what you'd like to do. I don't have any issue with that.
So just to clarify again, if we vote yes, that's, or depends on how you make it. It's to leave Mr. Vedder's.
Yeah, and it depends on who makes a motion, but the state's attorney recommended we make a motion to deny. If you vote yes, that means you would vote to deny that. If you vote no, that would mean you vote to uphold Mr. Vedder's decision. Am I correct on saying that?
And what I would do is I would make the motion if you want to overturn his decision.
Okay.
If you want to overturn it.
Okay,
His,
so,
his decision will be upheld unless it's overturned.
Okay.
by the board.
so you'd recommend a motion to overturn, and a vote yes means to overturn, a vote no means to not overturn and let his decision stand. Okay, that's probably a better way. Thank you, Rob. So, I would entertain a motion.
I'll make a motion to overturn Mr. Vedder's decision.
I have a motion to overturn Mr. Vedder's decision. Is there a second?
Second.
I have a motion and a second. Further discussion? Okay, so further discussion, a vote yes means to overturn, a vote no means to affirm Mr. Vedder's decision. Is that correct? Okay. Is there any other further discussion? Go ahead.
Yeah, I think so. I think the critical thing here was construction actually started, and I asked for the site plan to see if the mortality building was part of the site plan, and it is not, which is disappointing, because had it been there, it would have been much easier to say construction on the plan had started. It is above grade. It was completed well before the end of the expiration of the building permit. The other thing is what State's Attorney Clemish essentially said is his view of state law is that there is, for lack of a better term, an automatic extension for acts of God without actually coming before the commission. And am I quoting you correctly? There, I just don't want to misquote you there. So, and that would be approximately 3 months extension, and we would have to go back and count the days for when we release the roads from the time of the event itself. And that certainly would cover, in fact, the whole barn being built at that time. I wish I would have a copy of the official stay. I have been told the circuit court did not officially give a stay in this case, which could be problematic for that as well, which would mean the CUP would expire after the 2 years. So, other thoughts on those before we vote?
I had a motion and a second. Is there further discussion?
Just to make it perfectly clear, a vote no is to not overturn Mr. Vedder's decision, correct? Thank you.
And then the last thing is there's documentation that the applicant did ask if they needed an extension, and officially were not given a response.
I believe the Planning Commission made a recommendation, and the County Commission also made a recommendation that they needed to come
I guess I'd like
to
to
the
add
board.
one more thing before you. There was a lot of questions about work and not work and working here, working there. A lot of people couldn't work during the bomb cycle. A lot of people were out of a job. A lot of people had a lot of time on their hands. So it wasn't because they were overworked that they couldn't come in and reapply. I don't believe. Now, maybe they couldn't get in for a road reason for a few days or whatever, but everybody nowadays got 4-wheel, 6-wheel drive outfits, so not compared to like it was back when I was on the farm and when I was farming. Thank you.
All right. I have a motion and a second. Is there further discussion?
Point to the work that Mr. Swenson references. I don't think there's any question about whether the ability of the Gundersons to get in here is at question. The issue that I bring up about work is that they were doing a considerable amount of work that did not include site work preparation. It included the various things that you need to have to get through to get a process like this approved. And that included discussions with peer and DENR and neighbors and many things. So they have been working on this project continuously for probably 2 years or more, whatever the date is, goes back to 17. It's not whether they can drive a vehicle into town.
Thank you. I have a motion to overturn Mr. Vedder's decision by Commissioner Kettering. Is that correct? Seconded by Loest. Further discussion? Roll call vote, please.
Kettering,
Yes.
Loest,
Yes.
Swenson,
No.
Clemish,
No. Motion did not pass. Decision is upheld.
Thank you very much. May we be excused, please?
Yes. Entertain a motion to go back into regular session.
So moved.
Second.
I have a motion and a second. Further discussion? All those in favor say aye.
Aye.
Opposed? We are back into regular session. Commissioner Healy is outside. He may now re-enter. Is there anybody who'd like to make a public comment? All right, seeing or hearing none, I'll go ahead and close public comment portion. Entertain a motion to adjourn.
So moved. I'll second it.
Motion and a second. Further discussion? All those in favor say aye.
Aye.
Opposed? All right, thank you, everybody.